Coons Law. My name is Salamatu. So if you are new here, kindly subscribe and turn on the notifications button. If you have subscribed and you haven't turned on the notifications button, please do so that when we post new videos, you'll be able to know. So today we are going to talk about battery. Battery is basically committed when a person physically applies force to another person intentionally, irrespective of whether there was an intention to harm the person or not, right? So the tort of battery is part of a number of tortious actions known as trespass to person. So a very important thing when it comes to the tort of battery is to prove that indeed there has been battery. So there are some elements that you need to prove in showing that there has been battery in order for your action in the tort of battery to succeed. So now what do we do when we want to establish the tort of battery? So first of all, you must show that the person's act towards you was one direct. This means that the person's action towards you, in between the action and then the effect you suffered as a result of that action, there was no break. There was no third party contributing to that act. Now, the case you can use to establish battery is, one of the many cases, is the case of Scott v. Shepherd. Now, in Scott v. Shepherd, the defendant threw a squib into a marketplace. Someone else took the squib and threw it to another person. That other person also took the squib and threw it, and it finally landed on the plaintiff, which actually put out his eye. Now, when the issue came to court, the issue then was, could the defendant be said to be liable for the injury suffered by the plaintiff, the damage? But then the court held that yes, he could be held liable because his act constituted trespass. Now, this was mainly because his act was directly what caused the plaintiff to suffer the injury, because if he hadn't thrown the squib, another person would not have taken the squib and thrown it. So you realize that in terms of directness, all that you have to show is that the defendant actually the chain of actions between the defendant and yourself was not broken by anything, and that it was his act which had mainly caused you to suffer the damage. In effect, in trespass to person, and for that matter battery, the defendant will be held liable if his act was not consequential or the damage suffered was not consequential. The other thing that has to be proved is that the act was intentional. So the defendant must have intentionally caused damage to the plaintiff for an action in battery to lie. This is evidenced by the case of Miller v. AG, where a police officer, on suspecting that the plaintiff was a thief, decided to manhunt him or decided to go after him. In doing so, when the plaintiff ran away, he shot him, he aimed at his head and shot him, leading to the plaintiff suffering some damages in his skull. Now, the court held that the defendant was actually liable because to have aimed a gun or to have aimed a rifle at the head of the plaintiff the way and manner he did exhibited an intention to harm. So you realize that the intention will always be an objective test. It will always be realized as a result of an objective test by the court. The other thing that has to be established is that the act was voluntary. The act was voluntarily done by the defendant. Now, in Gibson v. Pepe, the plaintiff suffered damages by the horse of the defendant. The defendant had actually tried to start his horse, and he hadn't done so properly. So the horse got afraid, or the horse got startled, and then it started running. Now the defendant, sensing that there was going to be danger, started shouting at people to leave the way. But the plaintiff had not heard this shout in time, and so he had been in the way when the horse came to cause him damage. The defendant's defense was that, well, the damage caused was inevitable because as the horse was running away, there was a chance, or it was obvious that he was going to crash into some few things and crash into some few human beings as well. But the court did not accept that defense. They had reasoned that the defendant could only have not been liable for the ensuing injury if he had not been the one who had started the horse. So if the horse had run away to cause damage as a result of a third party striking the horse, then the defendant would not have been liable. But in the instant case, it was the defendant who struck the horse, and accordingly he was liable for all those damages that have resulted. So you can see that another thing that is key for establishment is that you must show the defendant's act was voluntary. Now, the other thing is you must show contact. Now, the thing about contact is that it must not necessarily be physical. It might be through a particular means or through a certain means. So that in RV Cottesworth, the defendant actually pat on the plaintiff, and it was held that this actually constituted some form of contact. Then there is consent. Now, consent, in the absence of consent, we can say that we can establish battery. It means that whatever act that you did to the plaintiff had not consented to it, or the plaintiff had not given his consent for that to be done. Now, the case of Nash v. Sheen establishes something. Now, what are the facts in Nash v. Sheen? Nash v. Sheen was basically a case where the plaintiff went to the salon and requested for a particular kind of hairdo. Now, the defendant did another thing on her hair, which resulted in her hair being dyed, and apart from that, giving her severe skin rashes. Now, the court held that the plaintiff had given a specific instruction, and the defendant had gone contrary to the instruction. Accordingly, the plaintiff had not given her consent for what was done to her hair. So the defendant was going to be liable for all the ensuing damages as a result of doing an act which he had not sought the consent of the plaintiff. So you realize these are the 5 basic elements you need to establish in showing that the acts of the defendant amounted to battery, or the acts done you amounted to battery. This is where we end. See you next time in our next video. We are going to talk about the various types of consent. Thank you very much for watching. Bye.